So hi Casey, great to see you, even
Hi,
if
Josh.
it has to be under COVID-secure conditions. You've had a big win in the past week in official receiver, and is it Batman Jelly? Is that how you pronounce it?
Batman Gurlich.
Batman Gurlich, okay. So tell us, what was the case about?
So Kids Company, as I'm sure you know, is a charity that supported children and young people in London and latterly in Bristol. It went into insolvency in 2015, and after an investigation by the Insolvency Service, the official receiver brought directors' disqualification proceedings against 8 of the former trustees and also Camilla Batman Gurlich, who was Kids Company's CEO.
And who are your clients out of these directors?
So I was acting for 5 of the former trustees, the most well-known of whom was Alan Yentob, but the others included a solicitor and several people who'd worked in big public companies, and there was also an HR expert.
Now, some of the directors were separately represented. Was there any scope for cooperation between the teams, or was this a sort of duplicated effort across everyone?
No, there was definitely cooperation. So, as you know, one of the things you have to do when you cross-examine is to put your case to the other side's witness, and if you don't, you can't then make the point in closing. So what we agreed with the claimant was that when one of the defendants made a point to the claimant's witnesses, the other defendants didn't all have to ask the same question. It was effectively asked on behalf of all of them. And so what that meant then is that all the defendant teams had to coordinate cross-examination. So we had to discuss beforehand, are you covering this time period? Which theme are you covering? So we were talking a lot before the trial and a lot during the trial as well.
The judgment came to 221 pages and was a resounding victory for all of the directors. Was the case really as open and shut as the judge made it sound?
I would say before trial, no, because we didn't know how the case was going to be put at trial. We didn't know that till we got the skeleton argument. And then during the trial itself, the judge really kept her cards close to her chest. We did not know which way she was going to go. So no, I don't think we didn't feel like it was open and shut, although obviously we got the result we thought we ought to have got.
And the case came against the background of 2 quite critical parliamentary inquiries. Did they play any part at all in the way that this case unfolded in court?
No, the official receiver rightly said that he would not be relying on any of those findings, and also parliamentary privilege means it was very difficult to bring in anything that was done in the committees.
The judgment also resulted in quite a lot of criticism of the official receiver, based on the need to give a balanced presentation and the sheer volume of the documents risking becoming oppressive. Do you think those criticisms were justified, or is that just the nature of dealing with a complex case involving a lot of characters?
I think the criticisms were justified, but I would say with some of them, having acted for the Secretary of State and the official receiver, you can see how it happened. So, for example, with the length of the reports and the size of the exhibits, that happens because the official receiver doesn't want to leave anything out. And because you don't usually have disclosure in directors' disqualification proceedings, it can be out of a sense of fairness that the official receiver says, here is everything that we looked at. And so that's why you end up with such long reports. Some of the other criticisms, I would say, were more unique to this case. For example, the lack of balance. That isn't something you see usually in other cases. And another one was the official receiver not being able to say, when he was cross-examined, why particular periods of disqualification were being sought against individual defendants. And again, that's surprising because he ought to know that.
So when there are concerns, for example, about the way that a case is being put, is there anything that you can do about that before you turn up to the trial?
Yeah, there are things you can do. There are things you can do before you even before the claim is even issued. So one thing that the Insolvency Service will often do if there's time is you can ask before proceedings are issued to see the draft evidence, the draft report that the Secretary of State or official receiver will be relying on. And if there's concerns about lack of balance in that, you can tell them before proceedings are even issued. Once they're issued, your options might be judicial review or summary judgment application, but those are pretty rare in directors' disqualification proceedings. And I know that this case looks open and shut when you look at the judgment now, but we have to remember that the judge had over a week of pre-reading. She spent 9 weeks hearing submissions, hearing evidence. She saw our clients give evidence sort of in person. And so I just wonder, would a judge have the confidence to reach the conclusions that this judge did after only 1 or 2 days of argument? And I'm not sure they would, because you would just have barely scratched the surface in that time.
This case has also drawn some comparisons with the Fairpack case, which probably would have happened right at the start of your career. That was another high-profile director's disqualification trial. where the official receiver discontinued halfway through. There were judicial comments on the volume of evidence, the lack of clarity about the Secretary of State's case, and there was also a tribute to the legal teams in each of these cases. Is it really a risk that there are directors out there who don't have access to the sort of legal representation that was available to the directors of Kids Company?
I think there is that risk. I don't know the proportion off the top of my head, but a very high number of disqualification claims go by way of undertaking, and a lot of those directors won't have had legal advice, or will have had just enough legal advice that they've been told this is how much it will cost for you to fight the case, and if you lose you'll have to pay the Secretary of State's costs. And so many directors in the face of that will just think I can't possibly fight this. So what they will often do instead is give an undertaking, and then they'll use what funds they have to apply for permission to act as a director, notwithstanding the disqualification.
And both Fairpack and Kids Company included a director who had given an undertaking. When that happens and the other directors fight the case and they win, what sort of scope is there for a director who's given an undertaking to try and have it set aside?
So if the disqualification period is still going on, that director can apply to the court under Section 8A of the Company Directors Disqualification Act for it to cease to have effect. And if the undertaking has been given on similar grounds to which the claim against the other directors was dismissed, then I think you probably have a pretty good shout. In this case, the disqualification period had already expired by the time we got to the trial, so that wasn't an option.
And does the court take a softer view, do you think, on charity trustees rather than directors of commercial companies?
No, absolutely not. Whilst we were keen to emphasise that the court takes a benevolent approach to charity trustees, that was not with a view to suggesting that there is a lower standard that applies to them. Rather, that the court needs to look at the context in which the director is operating. And where they're operating a charity, that I think is probably two implications of that. One is that usually you will only be there for meetings, and the way that you will be doing your directorship will be preparing for meetings and attending meetings. And if you're preparing for and attending, say, 10 meetings a year, there is no way that you're going to have the level of control and knowledge and oversight as someone who's there full-time, paid managing director. It's just not possible. And so if the same level of control and knowledge was expected, then no one would be a charity trustee. So there's that, and there's also the point that sometimes with charities the stakes are higher and there are other considerations that you will take into account. So with a company, if you're thinking money isn't doing so well, should we close? Probably all that will be at stake is jobs, which is, it's big. But with a charity, and with this particular charity, the trustees were worried that if they cut certain services or closed certain centres, that children would go hungry. And so of course they took that into account, and the judge said that that was right for them to do so.
And what did you make of the suggestion that the Charity Commission should discharge this public protection function in the future rather than the OR, where charity trustees are concerned?
Well, I would respectfully agree with what the judge said in her judgment, which is that the Charity Commission understands charities, that is what they do. And it was very clear in this case that the official receiver didn't. Because, for example, the official receiver, when he was giving his evidence, said he had never dealt with a big charity and seemed very surprised that you could have a board of directors who are all non-executive. But that's completely standard for charities, and so that's something the Charity Commission would understand, but it's more difficult for the official receiver.
Right, well, those are all questions that I had. Thank you very much for giving this interview.
Thank you, Josh.